Commentary on Thomas Aquinas' Treatise on Law by BUDZIZZEWSKI. And you can find his books online. I will try to post this in the comment section so that you can get the name and all that. But he does have a website online where he sells his books. And if I can find the website, I'll post that also. But in his book, he talks about positive law. He talks about it being an enactment, a voluntary act. So if you've watched some of my other videos, you see where I talk about the titles are either positive or they're not positive. So they've either been signed or they haven't been signed. And we know that president signs the laws, and then the laws are accumulated into titles, and then titles are either completely enacted or not. So we're going to look at what BUDZIZZEWSKI says about Aquinas' treatise on law as concerning positive law or law posited. So this is from page 313, and then this down here is on page 1, so it's kind of backwards, but it makes a little bit more sense that way, I think. In the sense employed here, positive law is law that has been posited, given legal force just through being enacted. And there's different ways of enacting a positive law. There's not just one way. A positive law makes an act right or wrong that would otherwise have been indifferent, like what to do when the signal light turns yellow. Although such a law can be posited either by human enactment or divine revelation, the objector is speaking only of human enactment, distinguished from what we know to be right by nature. Okay. The same distinction is implicit in ISIDORE'S TRIFOLD classification of natural law, civil law, and law of nations, and in Aristotle's distinction between natural law and legal justice. Okay, so in the history of jurisprudence, a good deal of trouble might have been avoided if only so-called legal positivists had paid attention to St. Thomas's analysis of positive law, especially in question 95, articles 1 through 3, and question 96, article 1. The objector's argument runs like this. Natural law is composed of A, the general principles of natural law, and B, the conclusions derived from them. But positive human law is neither A or B. It comes from nothing but formal human enactment. So Aquinas says that these other people are wrong, or Isidore is wrong, that positive law is not natural law, that positive law comes from a human enactment. So therefore we have some titles passed by human enactment, and then some titles have not been enacted, and so they are not law. Therefore, positive human law is not a part of natural law. In our system, our laws, I believe, such as the Constitution, are supposed to be in harmony with natural law. So it's not that they're directly from natural law, but they don't go against natural law, because going against natural law is can cross into compelling someone to do something that's impossible. So anything that is formally enacted by a human cannot compel someone to do something that's impossible, because that would be an act outside of nature. However, it doesn't have to address natural law, and it doesn't exactly come from natural law. So let's see. In a summary, because he goes on, and in a summary here, I put laws vary from place to place. They contradict from place and time. So how can it be that positive laws arise from nature? They do not arise from nature. They arise from man and their actions. So here he says a formal human enactment. So a formal human enactment would be like the signing of a law or a bill into law. Many titles are not signed into law. They contain things that may be signed into law, but the way the title is using them, the title together, all those laws together, are not made a law. And a lot of times, the titles not made law are composed of things never passed into law. Sometimes they're just composed of a lot of writings, just general writings, and then here or there scattered throughout some executive orders. Therefore, positive law is law because man, either individually or collectively, make it so. So through a signature, oftentimes, or through their acts. So an act is sort of like an informal contract, and a signature on a form is a formal contract, maybe said in many other ways. But to make a law positive, you're required to sign something, a formal human enactment. That's your enactment. It can be done individually, or it can be done collectively through the Congress. Okay, so if Congress wants to act outside the Constitution, they have to get an individual positive human enactment, and then that makes the law for you individually. So notice notice that this is a fundamentally moral approach. So he's talking about the morality of legal positivism, and whether or not the positive laws or the laws posited have a moral grounding to them. And he says even though positivists agree that the law should be or ought to be moral and good and just, that they're saying that they don't always address a moral standing inside their law. So there's some laws are like neutral. They're not moral and they're not immoral. I would say that just myself, that some things that people sign have a moral grounding to it because or an immoral idea within it, because they come about getting you to sign them in ways that are very deceitful. And the law should protect the deceived, not the deceiving, and we see that in the ancient legal maxims. The law protects the deceived, not the deceiving. So the contracts should not deceive, and people trying to get you to sign a contract should not be deceptive in what they tell you and what the contracts say. So there should not be any misunderstanding in the wording of a contract. It shouldn't, mean two things. One thing should not mean two different things, and then they just use whatever's in their favor. Nobody ought to derive an injurious advantage from his behavior. That would also be a legal maxim that should be included in morals when enacting laws. So my question is How many things have you signed because you're told you have to do a thing, but before you signed it, you didn't have to do it? It requires something from you, a formal human enactment. So, for example, if you, when you were younger, or even at this age now, or maybe your son or daughter, they want to join the military. In order to join the military, they have to go and they have to get a medical evaluation, and they have to sign a bunch of papers and take an oath. They're not going to be going into the military unless they sign those papers. That's the formal human enactment. So the paper, if I sign a paper, it doesn't include everybody. If you sign a paper, it doesn't include everybody. It only includes you. So it's an individual, voluntary, positive act or enactment. A deed, an act, an enactment. It's enacted when you sign it. So how many other things have you been asked to sign and told you have to sign it? But if you had to sign it and you didn't sign it, what can they do to you? Nothing if you didn't sign it. They can't do anything to you if you didn't sign it. But if you signed it, then you made it an act. You enacted it as a law for you. So he says, notice that this is a fundamentally moral approach to the definition of law. Against it standing something called legal positivism, the approach to law so dominant in contemporary law schools that law students may never hear of another. So, however, what positivists say is often misunderstood. Many positivists are perfectly happy to agree that law ought to be moral and just. That is not what they deny. So-called inclusive positivists even concede that, at least in some legal systems, the question whether an enactment is moral plays a part in deciding whether it is a law in the first place. So that is not what they deny either. However, positivists insist that even though such moral elements may sometimes be demanded, they are not logically necessary to the validity of law as law. That is what they deny. So they deny that every law has to have moral validity. I try to make sense of these kind of things by thinking of what examples of what they might mean. And so I'm thinking like a process or a way of doing things may be a law, but it is neither moral or immoral. It's just a way of doing something. So it's morally neutral. And there's a lot of those processes involved in various writings by whomever. And so this is what BUDZIZZEWSKI says about Thomas Aquinas' treatise on law and what Thomas Aquinas says on positivism. So positivism is a formal human enactment which requires your voluntary act, which is done by way of signature.